So Sandra responded to Mireille, and perhaps we can start by asking if Mireille would like to respond to Sandra.
Yes, let's keep that short, right? Well, let's say that I'm surprised, and I'll pick out one thing. You said that you generally agree, but I think we fundamentally disagree. So let's tease that out because it's interesting. I think the ex ante protection that you're looking for is precisely what I described in terms of data minimization and purpose limitation, where you said that it's not going to work with machine learning. The core of what I'm saying is if we want good machine learning, and there are magical expectations now of machine learning, like I said, micro-targeting probably doesn't really work. On the short term, yes, but not on the long term, because people are hugely clever. Data minimization and purpose limitation aligns perfectly with machine learning. So if you want to work ex ante, then I think that is going to save us, not all the explanation, blah, blah. So I personally am always disappointed that data protection lawyers put all their intellectual brilliancy into explaining why the GDPR and how the GDPR doesn't work. I have worked with the current legislation, and I've always said, just throw it in the dustbin, it doesn't do anything. And I've seen the process of the GDPR coming together, and I think it is brilliant. And I don't think we're ever going to get anything better, not at the global level, but also not at the EU level, because it's law now. So I see it as our task in the sense of professionally, but also scholarly, to show and to demonstrate how clever this has been designed, because I really think it is. And I think what we don't want is that these principles are going to be defined in any static way, like fairness refers to the whole case law of the court in Strasbourg. So the flexibility that is in the principles is precisely what we need. And at a lot of instances when you need certainty, just check the case law and you can have it. So we need this combination of flexibility and legal certainty. Legal certainty actually is about combination of stabilizing expectations, but allowing argumentation and change. We don't want anything static. And we really need purpose limitation and data minimization, because the world is now filled with data that are crappy, totally crappy. And so there I totally disagree with you. We don't need more banners and explanations. We need to make it good up front. And that's exactly what is going to happen. And I am a colleague of data scientists, and I totally surprised that you say that data scientists are flabbergasted by purpose limitation. You cannot do machine learning if you have no purpose. You will just end up with even unsupervised machine learning needs that. So that's it.
Thank you. Sandra, do you want a quick, very short response? Or?
Yeah, so I don't think that the principles are a bad idea, absolutely not. I think if we take them seriously, we need to talk to practitioners and machine learning experts and try to re-educate them, because I think that mindset has not arrived yet. I don't think they understand what data protection law wants, and I think this is where we need to adjust. I don't think it's a bad idea. I just think the mindset hasn't really arrived yet. So there's no disagreement in terms of that I think the principles are a good idea. I just think we have been doing different things for a very long time, and it takes some readjustment to think in different terms. And in terms of flexibility and how to phrase the law, it has, I don't know, usually if a law is very vague and agile, it's being interpreted in a horrible way. because you're going to have a lawyer that is exactly doing that and trying to bend it. If you think about the right to contest, for example, that's very clear, and I think it's good that it's very clear. You cannot argue with that. That's just there. A principle that just say be fair, probably not. It's not going to do the work. I'd rather see a system where you actually have a really well-defined rights and obligations, rather than just something that might go with time, because fairness will always be fashionable, right? But you're never going to know what to do.
Fairness has a very clear meaning in the case law, so I'm sort of flabbergasted, but maybe we should move to the...
Yeah, we clearly have a healthy disagreement here, which is good.
Good.
Perhaps, since we're here, just before we go on to other questions, because we're sitting in the Alan Turing Institute, where we do have some machine learning expertise, but I'll put my machine learning hat on and also maybe be a little bit provocative and just ask about why do we need to limit ourselves to specific purposes? In general, we like to encourage people to be able to enter freely into a trade. Into a trade or contract if they'd like to. Why do we need to prevent people from being able to sell their data without purpose?
Okay, so these are two questions. From the machine learning perspective...
I'm not weighing in on that, just...
Okay, but I think it's important.
Okay.
So I have the feeling that I don't have to change anybody's mindset in terms of machine learning, because the machine learners that I know, who are computer scientists, they will always have to define some sort of purpose. And now the issue is, that's the first law of informatics of Van der Leij, whether you can pick up data that have been collected for all sorts of reasons, and then use that data, because they happen to be around, for your own purpose. Now, I think from the perspective of the methodological integrity of machine learning, this can be highly problematic. And this is connected with the idea of working with low-hanging fruit. So you want to figure out how you can persuade somebody to buy something, which is a common purpose, right? And you're going to use data that have been provided and collected for totally different purposes. And then you're going to sell the idea to somebody else that this data is going to help you to do this. And because everybody buys that, so there's a difference between the advertisers, the people that want to sell toothpaste, for instance, and the intermediary who has been using machine learning to develop these profiles, right? This intermediary now is usually part of the corporation, the platforms like Googlebot, DoubleClick. So there is an incentive to tell the advertiser, if you advertise here, people are going to be more inclined to buy your stuff. That's the micro-targeting. Now, I simply don't believe that it works. So this is A/B testing, continuous. The more continuously you do it, the better it seems to work. But if you think about it, that means you are continuously making people click then on red, then on blue, etc., etc. People are so clever, after some time they just get exhausted and do what they want. So I think there's one particular entity that's getting very rich here. That's the intermediary, right? The advertisers might be very well off with... I got distracted, sorry. The advertisers might be very off with contextual advertising. But who's going to tell them this? Yeah, so, and this is all about advertising. If you think of medical science, there's a whole lot of research that shows Van der Leij came from medical informatics. He is a professor at a medical school. So there's a whole lot of research that shows that if you work with the data that happens to be there and then repurpose it, that leads to all sorts of misunderstandings.
There's lots to say about that, but let's open up to the floor. So you have a quick comment?
Because of something that you said, which I think is very important to keep in mind, because you said, why can't we just sell our data? I think it's very important to understand that the concept of selling your data is foreign to data protection law, and I think for a very good reason. because data is not being handled as a commodity or something that you can just sell to somebody, because data protection is very much linked with the right of privacy, right of identity, and all of that. So it's not just something you just give to somebody you can sell. If I sell my car, right, to you, there is no detachment anymore. There is nothing that will concern me with that anymore. If I sell you my data, there will always be a connection between me and my identity and the data. So we have a very different concept there. So I think the idea is completely different from usually property laws and data protection law. And I think that's the reason why we don't and should not sell data.
Good. So you're saying essentially that data is part of my privacy in a sense, but surely a little bit of data isn't. So when does it cross over into being in that area?
From a legal perspective? Well, I mean, it's a very good question. There has been so much discussion around what constitutes personal data and what doesn't constitute personal data. Some say it's very narrow, some say it should, be everything. I think it's very hard to determine where we should cross the line, because it's always called data protection, but we're actually protecting the humans behind the data. So it's very, very hard to draw the line and say, okay, this information does not concern me anymore.
Thank you. Questions from the audience, please. So please wait for the microphone and state your name and affiliation, please.
Hello, I'm Sheila Heyman. I'm from the MIT Media Lab. I'm not a lawyer. I may be an irritant, but maybe it's useful that I'm here. I've got one specific thing and two more general things. One is, on your last presentation, you said that there was an obligation to inform people of their rights, but then later on they said they don't have to tell you about your rights to contest the decision. So I'm slightly puzzled about that because I probably didn't understand. I'm probably not understanding anything, but that's part of my next 2 points, which is, firstly, how are people going to afford the legal costs of making any of these claims? And secondly, who is going to explain to normal... I've got a first-class degree from Cambridge and I'm completely lost, okay? Who is going to explain to normal people what these laws are, how they work, and what they can do with them? Sorry, that's it.
I think the first question is for you.
The idea is that it's just interesting that the framework lists all the rights that a data controller has to inform you about, with the exemption of the right to contest. You do have the right to contest, but I don't have to tell you about it.
Okay, so what are the rights that they have to inform you about then?
Your right of access, for example, your right to rectification, your right to deletion, the right to object, the right to lodge a complaint, basically every right that you have in a GDPR, but the right to contest. It's still there, but if I don't know I have that right, I might not exercise it.
Okay.
That's the problem that I have with that, and I think that's something that can be closed very easily if you just say, how about you just inform about all the rights and be done with it?
Okay.
Yes, the rest of your question, I think, is the most important question. So there are all these rights and these information duties, etc., etc. What are we going to do with them? Do I need a law degree to get my rights to work? There again, I think the GDPR is very clever. This is about data protection by design, about providing this information, for instance, in an intuitive form. Like if you compare the receiving a computer with a thick guide, manual, about first you have to do this, first you have to open it, then you're blah, blah, blah. This is when I grew up. You got this manual. Now you get your, I'm not allowed to use brands, but let's take Apple.
Something like this.
You get your Apple, there is no, yes, the fruity, the fertile fruity stuff. So you open it and you begin to work with it. That's called human-machine interfacing, right? So basically what the GDPR says, make sure that the defaults, also in terms of intuitive interfacing, are such that you're not taking data subjects for a ride. That's basically the bottom line. And I'm sure this is possible. And I'm sure that what the GDPR is going to do is create a market for this. So it's going to pull at the market. Once I have produced a technology, whether in the interface or at the back-end system. I think many of the problems are, by the way, in the back-end system. Once I've created that technology, and it's actually pretty good, then it becomes state-of-the-art, and then it becomes an obligation to use it. So it's not going to be, I totally agree with Sandra there, oh, I'm so ethical, that I'm supplying you with this. No, if I don't, I'm going to be fined. So it's important that, for instance, the right to consent, interesting that I'm saying the right to consent, it's of course a legal ground, that Article 7.4 and Recital 42 basically say, if you're asking for consent, split between the additional consent and the other consent. One of the reasons why you get cookie banners in your face is because companies have been very clever. They said, we're going to ask in one stroke the consent that we do not need and the consent that we want. Then if you say, no, we can't do anything, we put things on black. Now, Article 7.4 rules that out. So don't ask consent for things like session cookies, functionality, and also web statistics. You don't need consent, so you're not allowed to ask for it. Ask for the other consent and have a default setting that disallows that. We all know behavioral economics, blah de blah, that if you pick your default settings right, everything will start running smoothly. But that will mean business models will have to change and the back-end systems will have to change. And my point, that's not bad for machine learning, that's good for machine learning.
And what about the money? If people do decide that they want to contest a decision, who's going to help them pay for the lawyers?
Well, if you want to contest a decision, you can, you have like 4 different ways of doing that. You can write first to the company. Guess what? They're not replying, or they're sending you some highly interesting letter that you don't. So you send that letter to the DPA. Guess what? The DPA says, I don't have the money to go and look at your complaint. That's where it stops now, right? Then you go to court. This is administrative law. In principle, that's not going to cost you very much, and you do not need legal counsel. You just ask the court to go and tell the DPA to do its work. What you can also do is go to an NGO, public litigation. They're like mushrooming, understandably, because there is going to be money in this litigation. Yeah? So you mandate, for instance, you want an injunction. You can tell a company, okay, if you're not giving me what you're actually doing, I want you to now stop all the processing of my data, and I want a demonstration of that. Now you mandate that claim to an NGO that is, or a law firm who is specialized in this. That's why I'm saying Articles 78 to 82 are like a web, a closed web. If this doesn't work, that works. Think of what a law student, Mr. Schrems, got done so far. So I don't think the idea is that we're all going to be contesting everything all the time. The idea of the GDPR is that default things are going to be okay. And we need the contestation like pinpricks.
So it's not going to be like the sort of PPI thing where there are sort of millions of ambulance chasing lawyers with vague promises to get you your rights.
Yeah, the problem is that the United States legal system is so terribly different from our system. Here we have actually a default where all the processing of personal data has to comply. In the United States, it's like there is no obligation unless there are specific legislation, which is very confusing. Sometimes the protection is better, like I think in financial situations it's better, so it's not all bad, but it makes the system much more difficult to handle. What you see now is that big companies, really big companies that work globally, they're basically already preparing their back-end systems for the EU because they don't want to have one back-end system for the EU and one for the United States. So they're already doing that. Of course, they're going to be doing that very prudent. They'll wait for court decisions, but those decisions are coming. They're already being prepared everywhere. So I totally agree. We don't want cookie banners all the time. We want a default system that we can trust. At this moment, as the topical events of the past days show, we cannot trust the default system. We have to get away from there.
Thank you.
Thanks, Michelle. Lady here. Name and affiliation, please.
Hello, I'm Margaret Hartnett. I'm from ID Scan. May I ask the panellists how they view the potential conflict or indeed the potential relationship between the issues that you've addressed in relation to the GDPR and the broader concept of intangible property? More specifically, we've got database rights, which mean that data is a form of property. It has a value. So regardless of whether it relates to identity, it is a form of property.
Yeah.
Separately, we have the Trade Secrets Directive. So if we're talking about individuals having the right to ask how an algorithm works, intrinsically, it could be a form of trade secret. It is unlikely to be disclosed. And indeed, we could see situations where competing companies deliberately set out requests in order to obtain information about the trade secrets of their competitors. How do you think this is going to resolve itself?
I think that's a very, very, very excellent question, and one of the most important ones that will be decided in the next years, because it will be based on the jurisprudence of the courts and how they balance that. If you look at the GDPR itself, it's very clear that the whole framework is set out not just to protect individuals' privacy, but also guarantee the free flow of data, basically business interests. So every provision that you read is very much in line of counterbalancing, right? So there is no absolute right to privacy, data protection, there is no absolute right for trade secrets. So there has to be some balancing act. How this will work out in practice, I can't tell you. I looked a bit at jurisprudence in the past and exactly looked at the question of how much information do companies need to disclose if you're asked for it, and usually they don't get anything because they always put everything under trade secret, intellectual property rights, or whatever. I'm not saying that this couldn't change in the future. I really hope it does, because I think the question of transparency and accountability will be more important because we are moving towards a real AI society. So I hope that judges will be sensible not to grant companies too much claim over their intellectual property rights. But on the other hand, this could also be a problem. Like, do I need to know everything, right? Do I need to know how the Netflix algorithm works? Do I need full transparency for that? Who should know that? Because you could also think about like a balancing act. Does really every individual need to know how the algorithm works? Or is it enough if an auditor knows? If, for example, the ICO would know, would that be enough to find a balance between that? And I think that would be a very sensible approach because both interests are valuable, both interests are protected by law, and we need to find a balance here.
Yeah, I totally agree. I think in the recital, again, a recital of the GDPR and the DPD, this is already indicated. And I think the shift from the logic of processing to meaningful information about the logic of processing already shows that it is not expected that companies or government throw algorithms at people, which they will not understand anyway, but that they show on what factors, for instance, what features have come out is decisive for them. There are other questions like, do we want our access to knowledge, think search engines? Do we want our access to knowledge to be behind a proprietary algorithm? Do we remember that Sergey Brin and Larry Page wrote an article in 1993 on PageRank where in the annex they wrote, this should never be commercially exploited. What does that mean that they write that? And are then sort of, let's say, forced, incentivized by the economic system to still commercialize it? Database rights are not about the content of the databases. So the data is not owned. It's the structure of the database. There are two types. And I think there is a lot of agreement that the database directive is not very effective. So I personally wouldn't worry too much about that. I would say that data, whether personal or not, there are bundles of rights and obligations there. And sometimes they conflict, and then one might have to go to court. And the sooner it becomes clear what the defaults are here, the better. And I think that the GDPR provides such defaults.
Thank you for bringing up. It's a great topic. I can't help but just jump in and ask a bit more about rights to meaningful information and rights to an explanation. The idea that the GDPR perhaps does provide such a thing excited the machine learning community for a while. And I think the two of you have been great proponents, perhaps on opposite sides of whether on the extent to which there are such rights in there. And I wonder if it's possible just to summarize in terms of things like ex ante explanations, ex post explanations, specific explanations, or general explanations, what you believe is and is not in there. I know it's a big topic, but try to keep it short if possible.
Well, let me then be very brief. I have sort of steered away from that because I think that a lot of attention is going to this topic. How does all these algorithms work? How does, if you have a neural net, what is happening in the middle of the neural net? I'm sorry, but I don't think anybody is interested, also not data subjects. Oh, yes, of course, yes. I'm surprised because I think that machine learners are interested in how was this designed, what is the hypothesis space, that sort of question. So which data did you train up, how did you curate them, what is your performance metrics, how did you train on which metrics, what was the difference in the outcome? That is what you're interested in.
More.
Okay, you want to go into the depth of the neural net and see how the weights are shifted there.
We want to understand. Sorry, we'll take a second more on this, but in general,
that's interesting.
We're very interested to understand how it's working so that we can understand where it's likely to go wrong, where it's likely to do well, how can we improve the algorithms. And we don't really know very well yet.
Yeah, when I hear Geoffrey Hinton say that backpropagation is nice, but it's never going to win any prize. And he literally said, of course he's proud of it. He thought of it 20, 30 years ago, right? He's proud of it. But he actually says, I think we should throw backpropagation out of the window because it is stopping us from getting further. So I'm sort of surprised that somebody wants to know what is happening in the middle of the weight shifting. I would think you're interested in the fact that this weight shifting is happening based on certain approaches, certain research designs. And I'm sure that as a data subject, there are reasons why I want to know how a decision was made. There are the ex ante perspectives, so how is this being done in general, not just towards me?
So yes, no. Does the GDPR give an ex ante right, and does it give an ex post right?
It does, yeah, you can discuss about it, but I think the ex ante solution is data minimization and purpose limitation. And the ex post solution, so I think that the article 20, 13, 14, 15, so that's the transparency rights and the automated decisions, that they actually give you an ex post right. So you have to have some idea how in your particular situation the decision was made. But that means, like the German Data Protection Act said, you're paying this premium or you're not. I'm not giving you an insurance based on these three factors. That's why I think that the paper that Sandra wrote together with Brent Mittelstadt and Russell is brilliant, because this is the sort of information you want. Okay, so if I had another age, what age? I would have gotten a premium. If I've not had that accident 2 years ago, okay. So that is actionable information. I still think that is just a tiny little bit of the solution, because it doesn't always justify. If I ask a court, why did you reach this decision? And the judge says, well, I had a fight with my wife this morning, and you look like her, so you're going to jail longer. I would say, wow, I'm not interested in your wife or whether you have fights, right? I want reasons. So what the law actually does is constrain. Perhaps we have a tendency to operate differently as human beings based on what we had for breakfast, undoubtedly. But the idea of the law is that you constrain that. And maybe sometimes it doesn't work, but usually it does. So I want to know about the decisions. Give me a good reason. And if your only good reason is, well, I have this machine learning algorithm and it has a high performance accuracy. Oh, okay. Can you show me what you trained it on? What sort of hypothesis space did you develop? Did you develop others? Which ones did you throw out? Why? Did you use synthetic data? How did you make them? Which 3, 4, 5 performance metrics did you employ? What was the difference in outcome? If you can have that conversation, I don't need to know what in the midst of your neural net happened. Honestly, I don't think that's interesting.
Sure.
Do you want to add, or should we?
Yeah, just very short. Yeah, from a legal perspective, I don't think there is a right to explanation of an individual decision. I think you're going to have the right to meaningful information about the logic involved and significant consequences, but I think this is going to be very broad. It's going to be an overview of intended processing, so ex ante, not ex post. That's actually in the law itself, like it says in Article 12.7, that the notification duties should give you an overview of intentions rather than explanations after the fact. And the Article 29 Working Party in their guidelines have explicitly said that the notification duties and the right of access is not a right to explanation. I don't think that's a good idea. But like from a legal perspective, I think it's very clear that there is no ex post explanation. But I also agree that we might need to get away from fighting over what's there and what's not and think about what should be there and what we actually want. And that was, as you mentioned, we focused on that and thought about why do you want an explanation in the first place and work from that. And then figure out what kind of information you need to have to get that goal that you're pursuing, right? Do you want to contest it? Do you want to understand it? Do you want to alter future decisions with that? I think that would be a more reasonable way to think about explanations, because I actually think, as you said, understanding the source code, except for machine learning people, like it might not be super interesting, because if I don't get the loan, I don't get the job, I have to go to prison. If somebody shows me the source code, I'm going to be like, yeah, well, thanks, right? So I actually want something different, and we need to think about what that thing is that we actually want to know.
Perfect. And we'll be talking more about that in the afternoon. We have time for one more question, but then luckily people will also be around for questions during our coffee break.
Nora Neelajan, University of London, and thanks to both of the speakers for, well, not just for both really excellent papers, but for the disagreement. It's nice to get a bit of differing of opinions. So I do take the point in terms of going forward that counterfactual explanations, giving them the factors as to what influenced the decision, goes towards that meaningful explanation under the GDPR. What I am concerned about, if I don't get the loan, or if I go to prison, or whatever the ML algorithm has resulted in impacting upon me, is how much weight has actually been given to those factors. And ultimately, we're not really going to be able to find that out until you tease it out, you go to court, you go to the Data Protection Authority, and you pursue all those other remedies, which for most people is going to be a very torturous path to accountability. So it comes back to trust and trustworthiness. And I think under the GDPR, to go back to being more positive, now if you are a company that's processing a lot of data, particularly in machine learning, you have a requirement that you now have to have a data protection officer. And what I'd really like the panelists to know, to say is, do they think that data protection officers in companies are now going to have to be a lot more public facing in order to take into account reassuring customers and consumers that no, this company is meeting up to its requirements under the GDPR? Because right now they're very much back end, but do you think that they're going to now take a much more public facing role?
I start with the counterfactual question and then with the DPO question. Yes, I agree. There is no legal requirement to tell you what kind of weight was attached to the different data points. But with counterfactual explanations, it would actually just return you the variables that had the most influence on it. So you might not need to know about everything. You would, with counterfactual explanation, you would actually know what was the most important thing in the decision-making process. It would actually address your concern. The other thing with DPOs is, I don't know. There are a couple of things there that I'm not entirely convinced it's going to work, because a DPO has the responsibility to more or less, make sure that the company is in compliance with the law and supervise everything, right? This can be somebody from their internal staff. I'm always a bit concerned if somebody who is supervising or investigating if everything is working as intended should be somebody that's internally, right? Or should there not be somebody who is looking at this externally? I don't know. But I agree, if it's going to be meaningful, and if that data protection officer actually takes the role seriously of showing compliance to the outside world, I think you're right. There needs to be much more communication and openness, so the people who are actually concerned with privacy have a way to assess whether it is working in practice or not.
I think the role of the DPO is going to change because the GDPR talks to the CEO, to the board, with its fines, etc. It means that the weight of the DPO will be very high. I think the board will tell the DPO, you just take care that we're in compliance because I don't want any fines or reputation. So there, I think we're in a totally different situation. Whether that means that the DPO is going to go outside, that I don't know, because that will create all sorts of liabilities. So I'm not sure about it. Depends on the company, I think, but I would expect not. About the famous ex post, ex ante position, I think if you look at explanation from the perspective of justification, which I think is the core perspective that we need, then you will want to have an answer. What is the reason why you decided to raise my premium or refuse an insurance? And that means these variables will be coming out at some point. So I think in the end, if you combine the different articles in the GDPR, like data protection by design, if you apply that to these three information rights, then at some point the backend system will have to be such that you can quickly give these sort of explanations in terms of reasons. And then we still have some problem because you will need a watchdog to test whether the reasons that are given were actually the reasons of the systems. Besides that, I think many of these systems are, for instance, A/B testing all the time. So this will be very dynamic. And that means, again, that what you don't want is some sort of static answer, but a perspective on how was this designed. And actually, the longer we talk about this, not today, but we've been talking about this for, say, 15 years, the more I become convinced that the micro-targeting that we are talking about is not really very effective and is not going to be what informs business models 5 to 7 years from now. So I think the competitive advantage will be with companies that figure out where using these systems is a competitive advantage and where it's going to be, you know, a lot of money and investment and not really working.
That's a perfect place to break. Next session, we will be hearing perspectives from companies in the real world. Let's thank the speakers.